On January 6th, something unprecedented happened.
You are enemies of the United States of America!
What patriots do? We fucking disarm them, and then we storm the fucking Capitol!
The sitting president tried to stop the peaceful transfer of power on live television, and no jury ever heard the case. Not because the evidence was weak, but because criminal law has limits. Criminal law does not explain the world. It reduces it. Before anyone can be charged, a complex event has to be broken into acts, intent, and causation, each provable beyond a reasonable doubt. January 6th sits at the outer edge of what that system can handle. This episode is about why. To understand why January 6th was so hard to prosecute, you have to understand what criminal law requires. Criminal law does not explain events. It asks what can be proven, against whom, beyond a reasonable doubt. That means breaking chaos into elements, specific acts, specific intent, and a provable chain of causation. If any one of those fails, the case will fail. January 6th was not a single act. It was a sequence of events, and sequences are harder to prosecute. Intent is rarely confessed. It is inferred. Prosecutors infer intent from patterns, repetition, escalation, and how someone responds when earlier efforts fail. Recklessness and intent can look similar. The difference is in their structure. Recklessness reacts. Intent organizes behavior around a goal. It applies pressure, it repeats demands, and it escalates when resistance appears. That is how prosecutors evaluate conduct, not by reading minds, but by asking whether actions drifted or moved consistently in one direction. January 6th did not arrive suddenly. After the election, the first strategy employed was legal. More than 80 lawsuits were filed alleging fraud. Nearly all were rejected, often for lack of evidence. Of the few that did succeed, they were minor procedural things that did not have an outcome on the balance of the election. That avenue was closed. Pressure followed. State officials were urged to change results, delay certification, or find votes, even after explaining they lacked the authority to do so. When that failed, attention shifted to the Justice Department. Senior officials were pressed to announce investigations that they said were unsupported by evidence. When they refused, they were threatened with removal. At the same time, alternate and illegal elector slates were assembled in 7 states. These slates had no legal standing. They depended upon delay and confusion. Each effort targeted a decision maker at a critical point in the certification process. By early January, Congress was the very last obstacle. January 6th was not chosen at random. Speech becomes legally significant because of its context. Timing, audience, and opportunity are factors as well. January 6th was the final constitutional step in the transfer of power. The rally was directed at supporters who had been told repeatedly that the election was stolen and that lawful remedies had failed. Many traveled to Washington because the day had been framed as decisive. The certification was happening in real time on that day in a specific place, with the crowd physically nearby. That combination matters. Debate often centers on individual lines from the rally speech. That is not how prosecutors evaluate speech. Single sentences rarely decide cases. Disclaimers do not automatically negate intent, neither does the absence of explicit commands. What matters is whether the speech advanced an existing objective in a context where action was realistically available. The speech mattered because of how it fit into a broader pattern. In speech cases, what happens afterward matters as much as what was said. Prosecutors look very closely at how a speaker responds once events begin to unfold. On January 6th, violence escalated over time. Senior officials were aware that the certification process had been disrupted. There was a prolonged delay before a public effort was made to call off the crowd.
So did you develop evidence that President Trump was responsible for the violence at the Capitol on January 6th?
So our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him.
But you don't have any evidence that he instructed people to crash the Capitol, do you?
As I said, our evidence is that he, in the weeks leading up to January 6th, created a level of distrust. He used that level of distrust to get people to believe fraud claims that weren't true. He made false statements to state legislatures, to his supporters, in all sorts of contexts, and was aware in the days leading up to January 6th that his supporters were angry when he invited them, and then he directed them to the Capitol. Once they were at the Capitol and once the attack on the Capitol happened, he refused to stop it. He instead issued a tweet that, without question in my mind, endangered the life of his own vice president.
During that delay, the disruption continued. When weeks of pressure are followed by inaction as that pressure produces unlawful results, the absence becomes part of the evidence. The question is not whether violence was desired, but whether unlawful disruption was accepted as a means to an end. Prosecutors believed they could show that Donald Trump understood he had lost the election, understood that lawful avenues had failed, and nevertheless pursued a course aimed at stopping certification. That theory relied on cumulative evidence, pressure on state officials, efforts to involve the Justice Department, alternate elector schemes, the focus on January 6th, the rally speech, and the refusal to intervene. Taken together, prosecutors believed intent could be proven. Now, the lack of a verdict is often misunderstood. The case never reached trial. Litigation over immunity, jurisdiction, and timing created delays that collided with an election calendar that no court controls. Courts do not rush criminal cases, especially when unresolved constitutional questions are involved. No jury heard evidence. No judge weighed testimony. The process stopped before those things could happen. January 6 matters because the legal questions it raised remain unresolved. The episode exposed a gap between moral responsibility and criminal accountability, a gap that's built into the system. Criminal law is narrow by design. Understanding its limits does not excuse what happened. It explains why accountability took the form it did. I'm Mike Burns, and if you value this kind of work, please like and subscribe. This has been the Knuckleball. Thank you.